SJC-12919, Commonwealth v. Jorge L. Delgado-Rivera.
Mr. Charles.
Thank you. Good morning, Your Honors. Assistant District Attorney Jamie Michael Charles for Middlesex on behalf of the Commonwealth. As this court has held, Fourth Amendment rights are personal and cannot be vicariously asserted. This is a case that can be resolved through traditional standing principles which adequately protect this defendant's privacy concerns. I think it's important to remember at the outset that we're not talking about, as Riley put it, the vast quantities of digital information that reveal the privacies of life that might be implicated by a search of this defendant's phone or his provider records. Rather, here the defendant's purported interest is a tiny sliver of information that resides on Mr. Castaneda's phone, a single conversation that the defendant engaged in, or even a single text that the defendant sent, knowing that a digital copy would reside on the recipient's phone. And I want to be clear, the Commonwealth's not questioning a defendant standing to challenge a search of his own digital device or the data that he has stored with a service provider. But this is not the surreptitious interception of a real-time voice or digital conversation. It's not the surreptitious interception of real-time location data. It's not the seizure of a digital device and all the intimacies of a person's.
Charles,
yes.
I think what the defendants might be arguing here is if you take Commonwealth versus Fulgham, which obviously dealt with a defendant's own phone, and you take the reasoning in the Washington State Supreme Court case in Hinton, that we have here is a subjective and an objective expectation of privacy just in the nature of text messages.
So just to be clear, before I dive into that, no court, state or federal, I recognize we're talking about Article 14 here. Although as an aside, I don't believe it was litigated below, but there's quite possibly a choice of law issue here involving whether you apply Texas or mass law. But putting that aside, no court, state or federal has ever found standing in these circumstances under the Fourth Amendment. And even State v. Hinton, which found it under its state constitution, did so in a split decision that relied on a constitutional provision that does not apply a reasonable expectation of privacy analysis. It applies a more rigorous analysis. I tried to give an example in my brief. For example, in Washington, warrantless trash pulls are unconstitutional under the corresponding state privacy provision, whereas they're clearly not in Massachusetts. Same thing with bank records, which in Massachusetts can be obtained via subpoena. You need a warrant in Washington to obtain any form of bank. So just to be clear, State v. Hinton, I mean, I'm not discounting that they reached that conclusion, but they didn't do so under the Fourth Amendment, and they did so under a state constitutional provision that is even more rigorous than Article 14.
How important was it in Hinton? I know I'm interrupting my own question, but how important was it in Hinton that the text messages hadn't been delivered?
So it's hard to quantify exactly how important it was to the analysis, but I did point out in my brief that it appears in the way the court wrote the opinion that they viewed those messages, because they had not been viewed by the recipient, as being quote unquote in transit, and that is more consistent with what federal and other state courts, not this court unfortunately, but what other courts have discussed more in depth regarding letters or other forms of communication that remain in transit, that have not reached their delivery point. And that's sort of pivots nicely into what I was just going to say, which is this is why we're talking about something that's different than this court's pronouncement in Augustine or Fulgham or Almanor or the Supreme Court's decisions in Carpenter and Riley. We're talking about data, or not a communication that has reached its recipient and been received and viewed. So while this court, again, has not specifically opined on this subject, there's plenty of federal circuit courts and state courts that have determined, for example, letters, communications via pagers, emails, all of those different sorts of communications, once delivered, courts have opined that the sender loses standing or a reasonable expectation of privacy, however you want to categorize it. I understand here in Massachusetts, it's a somewhat divergent analysis, although there are overlapping parts. But again, I just have to stress, we're not talking about what was at issue in all of the cases I just cited, in Fulgham and Augustine specifically. We're not talking about a search of the defendant's cell records or the defendant's phone, where there's potentially a huge quantity of data on that device. We're talking about a single conversation that resides on another person's phone. It's a
You're
very
saying that the sender of the text message doesn't have any right to challenge this. Right?
I wouldn't say that he doesn't have any right. I certainly think while this court has not acknowledged, or not, let's say not acknowledged, but not applied target standing in this Commonwealth, if you were faced with a factual scenario where clearly a third person's phone was being searched for the sole, warrantlessly and without probable cause, solely for the purpose of getting, say, Mr. Delgado-Rivera, I think that would probably present the sort of egregious misconduct that might compel this court to apply target standing. But I think we have to distinguish standing to challenge the search from the legality of the search. You have to have standing before you can question the legality of the search. And if you apply,
they have no standing, the sender has no standing ordinarily.
I'm saying that no court has found that under the Fourth Amendment. This court has never found it.
Right? You're saying no court has. You're saying no court has, but that doesn't answer the question, does it?
No, and I'm saying that I don't believe this court's Article 14 jurisprudence concerning digital devices is directly applicable and compels that conclusion, because this court's jurisprudence concerns, again, either surreptitious real-time eavesdropping or the search of an actual device that belongs to the defendant that could contain gigabytes or even a terabyte of data, or the same in the context of a third-party provider. Whereas here what we're talking about is a third party's phone that may have a lot of data on it that is relevant to that third party, but the only data of the defendant.
Excuse me, it came from the sender. The material that you're looking for came from the sender, right?
That's correct, and the sender no longer has any control over that message that has been sent. He lacks the ability to control what the recipient does with it. Just, this is why in modern times we recognize, we tell our children, I certainly tell my children, don't send anything that you don't want to see on the internet or on the front page of the Boston Globe, because we accept as a society that you don't know what's going to happen to a digital communication once you send it, once it is out of your control.
Before you get to the objective, and that point does go to the objective expectation of privacy, but is there something different about text messages? You've got the First Circuit has addressed this issue in United States versus Dunning, and then we have United States Court of Appeals cases and Lifshitz and Guest, and that deals with emails. So the question for us is, if we're looking at those doctrines, is there something different about text messages or not really?
So my short answer is not really. I don't believe there is. And I think it's telling that both my brother and the ACLU in their Amici brief talk about the Commonwealth's mention of letters, but completely ignore emails. If you look at the Warshak case that my brother cites in his brief, now in that case, that happened, I believe, is a little more than a decade earlier. And in that case, they were talking about emails as the new communication that everyone is using to express their thoughts and emotions and opinions. And it was, right? I mean, when email first came out, it was more prevalent for conversations I would submit than text messages, because text messages were a little more limiting back in the early 2000s in terms of what you could do with them. But notwithstanding that fact that emails were essentially what I would submit are the old text messages in terms of how prevalent they are in terms of online conversation, courts still have found, like you said, in United States v. Jones, for example, all of these state court decisions that I cite now, Tentoni, Carl, the District of Massachusetts in the Johnson case I cite, Lifshitz, Guest, they've all found that once an email reaches its recipient, the sender no longer has standing. And there's no principled reason why this court should distinguish an email and a text message. They're both, as the Patino case recognized, I'm just going to quote it, there's no media more susceptible to sharing or dissemination than a digital message, be it a text message or an email, which vests in the recipient a digital copy of the message that can be forwarded to or shared with others at the mere click of a button. And again, just to get back to the anecdote I was making before, this is why we tell our children, or why people generally understand, that you have to be very careful when you send a message or a file over a phone or the internet, because these things, they do not disappear once they're sent, and they can very easily be reshared or further disseminated.
Mr. Charles,
yes.
Would it matter if they do? I mean, because we now have all of these texting and email devices where we can send something that is supposed to disappear supposed to be written in basically digital disappearing ink. Would that matter? Is you are trying to protect the confidentiality of the communication beyond the person you sent it to, just so it's just sent to one person and you don't want it distributed further?
Again, I would say two things, and then I'll first, that is a subjective expectation of privacy that you have. And second, on the in this case, there's no indication.
Isn't it an objective? Because I'm using a device where I'm trying to protect the privacy. I understand the facts here are different. It's not one of these disappearing texts, but rather.
Oh, you're asking me if I was, say, using Telegram or Snapchat or something.
Yeah.
Is that essentially what you're asking me?
Because I'm clearly trying to protect the communication from anyone but the one person I've sent it to, and I don't want them to be able to pass it on. I'm trying to control access to that communication.
So what I will say to that, the Commonwealth is not discounting the possibility that there is a set of facts that could exist where on the specific facts of that case, you might say, you know what, here, there was enough indicia of an effort to, whether it be the use of an encrypted communications program that is not supposed to be viewable by anyone who generally accesses the phone or what have you, that you might be able to say, yes, in this specific instance, they're standing. But the Commonwealth's position is that as a general principle, no court has held, and in fact, several courts have held to the contrary, that there is no reasonable expectation of privacy in a text message that has been sent and now resides on a third-party device once it is received by that person, for all the reasons I've been stating, because it
is the objective prong, as Justice Lowey points out, correct? So Justice Kafka asks us about technology that allows for messages to evaporate. That may be something objectively we would accept, correct? But the regular text message, even if you put in the text message, we're doing drug deals, delete this, right? You still lose control over it.
That's correct. And I mean, just another anecdote, as this court recognized in Durellis, right? Anyone can screenshot a text message and store it in the photograph file of their phone. And you have no control as the sender over whether the recipient is going to do that. And if the recipient's phone happens to be searched later on and you anticipated he was going to delete it, but it's sitting there, and even if the phone automatically deletes it because, say, you clear your messages after 30 days, but it still exists in the photograph file because that person chose to take a screenshot, which takes a fraction of a second to do. It's going to be there, and you completely lack control, which has been the focal point of all these other cases that have focused on this recently. And I think it's telling that the two most recent courts to address this,
would an example of control be that if you and I are engaged in surreptitious behavior and I come up to you and I whisper something to you in a public place, that's one thing. But if I'm on my cell phone blabbing on the commuter rail like the people that annoy me do, I've lost all sorts of control, correct?
I think that's a fair assessment. Even as the Supreme Court recognized in Katz, the issue in Katz was that this individual, while he was in a public phone booth, was in the phone booth having a private conversation. He didn't expect to be surreptitiously recorded in real time. The same thing with this court's decision in Blood, which is not the same thing as having a text message conversation, which everyone in our society understands creates a digital residue of the conversation that may continue to reside on the other person's phone. Everyone conducts these conversations accepting that that's the case. Text messaging technology, while it's evolved, is not new. It's been around for decades. People have always understood that the text will reside on the other person's phone. And I think that's just to pivot, because I'm running a little low. That's why this court's sort of limitation of the third-party doctrine in Fulgham and Augustine doesn't really apply here. When we're talking about a third-party intermediary, such as a cell phone provider, an internet service provider, those are the sort of examples that Justice Sotomayor gave in Jones in her concurrence when she was talking about the potential need to limit the third-party doctrine. That's completely distinguishable from an actual third-party recipient that I voluntarily send a message to. I may be constrained unavoidably to provide some data to a third-party intermediary because that's the cost of doing business in the modern age. And that is a justifiable reason why you can say you don't voluntarily disclose your information to those people. The third-party doctrine shouldn't necessarily apply. But I'm knowingly choosing to send a message to somebody who I'm conversing with, knowing that a copy of that message is going to reside on their device. And as I was saying before, the two most recent cases, the Boyd case and the Armstrong case, which I cited in my 16L letter, they both recognize that there's this distinction between an intermediary and a recipient. And they acknowledge that they protected records in the custody of a third-party intermediary for various reasons, such as the ones I've just outlined. But a recipient, someone you're voluntarily conversing with, is different.
Mr. Charles,
I'm sorry, Justice Lowy, then Justice Seifer.
no, go ahead, Justice Seifer.
My question might take us in a little bit of a different place, but I was wondering if you could talk to me a little bit about what the amicus says about the Mubdi decision in terms of it expanding standing or expanding standing, I suppose, thinking that we're going to, and whether you think that's right.
Are we talking automatic?
Yeah, well, Mubdi had some language in it that said as long as someone has a reasonable expectation of privacy, anybody does. And I want to know whether if that's what they were referring to in the amicus and what you think about that.
So it was my understanding that they were referring to essentially pleading with this court to expand its automatic standing jurisprudence, which it will not surprise you to know that the Commonwealth would strenuously oppose. There's no reason to do that. I mean, the basis of automatic standing was essentially, when we're dealing with possessory offenses, we recognize that sometimes possessory offenses arise in circumstances where the object that is the subject of that crime may not reside in your house. It might be in someone's car.
We can narrow this a little further. Do you think that the language in Mubdi that basically said, and I think it cited Carter, but I'm not sure it cited Carter properly. Do you think that was a correct statement? And is that what that opinion intended? If you know.
I guess the way I understood it was in the context of automatic standing, as long as someone has an expectation of privacy, even if it's not you, and it is a possessory offense, you would have standing. But that is not, there's no reason.
If it was a possessory offense and you
were
had a
charged with
possessory
possessing it.
If you had a possessory interest.
Correct.
All right.
Here, I'm sorry, I was just saying here.
I think, I don't know if you finished. Have you finished the answer to Justice Seifer?
I guess the only other thing I wanted to say is here, obviously, there's a text message that is some form of evidence against you in a crime, but it's not a possessory crime that is proved by the possession of the text message. So there's no correlation between what this court has discussed in Mubdi and its automatic standing cases. And and if I'm misremembering the case, I apologize, but I think it's apples and oranges. There's not really any need to go beyond traditional standing principles here and create a whole new prong of our automatic standing doctrine for sent text messages.
Let's go to Justice Lowy if he still has the question.
I'm going to waive it, as we say.
Okay. Any further questions, Mr. Charles? Thank you, Mr. Charles. Mr. Bachrach, please.
Thank you.
Good morning, Your Honors. My name is Barry Bachrach, and I represent Mr. Delgado-Rivera in this case. I think it's very important to express that text messages are different. Text messages are a conversation akin to telephone conversations, which the United States Supreme Court has been protecting since at least 1967 in Katz. And I would submit that the issue here, if you look at the issue focuses on, in our case, I acknowledge that putting aside the automatic standing, I believe that there's a reasonable expectation of privacy in the sent text message. And in Fulgham, this court said, after citing Riley v. California, which case requires a search warrant to search a cell phone, the courts said the sending of text messages creates an expectation of privacy that is virtually identical to that associated with more traditional conversations such as a telephone, that's my line, such as a telephone, and concluded that the Commonwealth may not obtain the content of text messages without a warrant.
Well,
And
you
that
know,
was,
Mr. Backer, you know, of course, that that was the defendant's text messages. But if we can go back to the issue of that you started with, the expectation of privacy and if text messages are different. Why isn't what Mr. Charles was saying correct about what we tell our kids and just sort of the way the world works now, that when you hit that button on the phone and you send something, you've just lost complete control over it. No matter how much you may urge the person on the other side, that's in their hands. You've lost complete control over that message or whatever else you send when you hit that button.
well, I disagree, or I don't disagree that there's something happens when you hit the button, but I don't believe it's an issue of you lose control. The issue of texting is texting, as I mentioned, is different and was replaced, and statistics show it's replaced the modern phone conversation. And in fact, I think the historical background provided by the amicus and this court has indicated the prevalence of texting and the prevalence of cell phone use. And the issue becomes, I can cite many examples of people who text to keep things private. You'll have a room full of people, and I've sat in them, where people don't want to talk out loud and say what they're saying, so they text someone because they view it's private. And they're texting it one person to another, and it's a private conversation intended to be private. And the fact of losing control is someone could orally, if we're using Mr. Attorney Charles' theoretical, that, or excuse me, Justice Garziano's, that you're in a train and you don't want people to hear what you're saying, and so you text your personal intimate, it could be personal intimate details of your life, nothing criminal.
What do you say about what do you say about the Rhode Island Supreme Court decision in Patino?
Well, I think that decision has is very different. Number one, there was a search warrant in that case. Number two, in that case, there was written consent given by the person whose phone was searched. She gave written consent, and
That might not be, that's not my memory of it, but okay.
Excuse me? I'm
Go
sorry.
ahead, I apologize. Keep on going, Mr. Beckman.
There was the court did not base its decision on the fact that it was written consent, but it was a factor. And it was decided in 2014, well before Carpenter, which the United States Supreme Court decided the location, what was decided in Augustine.
But the ruling is based on control in Patino, right? It's these other factors are, and you know, in Carpenter's different because we're really talking about this one text message. It doesn't reveal the whole person's life. It just reveals, you know, the transaction that's at issue. I'm just not sure why Patino isn't correct. I mean, it focuses on control, and if you want to control your texts, either put them in disappearing ink or don't send them. Call them up. Use the phone. You know, that same phone, you can have a private conversation on the phone.
And I'm sure as people know that, they will do those types of things. Not everyone in our society is even knows the existence of many of these items, and yet they believe they're using texting to talk to privately to other people. They take the risk.
Can I interrupt you for a second here? Because I'm really puzzled here about it, because the question is, where does it fit more? Does it fit more in the telephone conversation category, or does it fit more in the email category? text messaging, I'm saying. Now, there's a sense in which text messaging, certainly watching my teenagers with their magic thumbs, I can certainly tell you that texting is like conversing. In fact, they'll even say that they've had conversations with somebody when they met what they had as a text session with them in a way that they don't use email. But still, with a telephone conversation though, I mean, you're assuming it's always going to be private, but I mean, what prevents somebody from putting it on speaker and letting everybody else in the room hear what you're saying? Or from having it be recorded in some states. One person's consent is enough in some states, not in Massachusetts, of course, but so I'm not really sure what I see as the difference between texting and telephoning and texting is emailing. I wonder if you could address that, please.
Where do I see a difference?
Yeah.
I see a difference because texting has, I don't see a difference to the extent that a text message is a conversation. A phone call is a conversation. This Commonwealth has indicated the importance of protecting oral conversations by the wiretapping law. The text messages are the flip side of have become the flip side of the, the phone call, where Judge, in your hypothetical or question, phone calls, sometimes you don't know who you're talking to on the other side, whether there's people listening in, whether it's on speakerphone and you're not told. So you don't necessarily have control over everything over your phone call either, but that phone call is protected. The text messaging should receive.
But that phone call is protected by statute, correct?
By statute and by the Fourth Amendment and this court's Article 14. That phone call would be protected, that it could not be intercepted without a warrant. And
how does that differ from email, though? I guess that's the question.
I'm sorry, I didn't hear you.
How does that differ from emails, though? Because emails are not so protected, right?
Because I think you need to look at the nature of cell phones and emails which come from laptops and
cell phones.
I don't think yes, you can email on cell phones. I don't, but just because I don't know how to figure it out. But with respect to emails from cell phones, I don't believe the issue has been addressed on emails coming from cell phones, which may be the next step, because the cell phone to me is different from, traditionally emails came from computers, and you would get, it was more akin to a letter. It was a correspondence, whereas a cell phone is something you carry around with you all the time, and you use it in connection with texting. You use it in lieu of making an oral phone call. One can email from a cell phone, but again, I don't think that specific issue has been addressed, and I think it should be addressed differently.
Mr. Bachrach, can I ask you, Mr. Charles gave us an interpretation of the third-party doctrine, why we would interpret the stuff the telephone company preserves versus an email. You want to take a crack at why the third-party doctrine, we should carve a big hole in it here?
Your Honors, I don't think we're carving, just with all due respect, I don't think we're carving a big hole in it. I think frankly, this case is a logical extension of Augustine and Fulgham and Almanor, which
well, Mr. Charles says, look, you don't have a choice with the phone company. I don't know if that's exactly true, but you do have a choice of sending your information via a text, sort of involuntary versus voluntary disclosures of information. You want to sort of massage that a little bit for us?
Well, once you text, it's voluntary, and it goes to it's stored in the the cell service provider stores it, and it's as much out of your hands and out of your control as when it also hits the recipient's cell phone. To me, there's no difference between it being stored by the cell service provider
Mhm.
and you
So-
have.
So the fact that we carved a hole in the telephone company information suggests to you that we should do the same for this kind of communication because they're both voluntary? Is that?
Well, they're both voluntary, and this court has said in carving what I believe it said was a narrow part of the third party. This court said in Fulgham, citing Augustine, we further stated that the nature of cellular telephone technology and CSLI and the character of cellular telephone use in our current society render the third-party doctrine inapposite to that case. And it just wasn't, this court is focused on what's the nature of cell phone technology, what's the character of cellular use in our society. And this court's decisions, as well as the statistics that were provided by the amicus brief, this court has shown that cellular telephone technology is new. It's expanding. It's something we need to address. And we shouldn't lose rights because we have new technology. And this court has indicated that we shouldn't lose rights because of the use of new technology. Texting obviously didn't exist. I don't think it was very popular 20 years ago. I mean, this is a more recent phenomenon that's grown in the past decade, and it's become a primary means of communication for many people who would rather text than talk. And this court has always focused primarily on the protection of conversation.
Is there an issue of whether or not we should be applying the law in Texas? Because, you know, if there's an interrogation, for instance, in New York, and there's no one in the police department offers the defendant a telephone call, we have case law that suggests, well, that's not required in New York. The search that took place is in Texas. Is there any argument that in determining the objective expectation of privacy that we should be looking at Texas law?
I think that no, because Your Honor, the illegal, what was determined in the illegal search occurred in Texas. Information was found in Texas. But then if you look at the amount of contacts and the information that they acted upon from that cell phone and what they did in Massachusetts to further the investigation, I would say the substantial contacts are here in Massachusetts. And I don't think that the Massachusetts court should cede to Texas law, which I don't believe is Texas law hasn't been, there is no Texas law on this issue that I ever found.
Any further questions for Mr. Bacharach? Thank you, counsel.
You're welcome. Thank you.